Next up, we talk about the first two of several challenges, threats, and problems associated with AI-written songs. Hey everyone, I'm Charles Dominick, the CEO of CLEID, the Council of Legal Education Innovators and Developers. Welcome back to part 3 of our 6-part series on protecting the art and business of human songwriting from an AI apocalypse. In part 1, I gave you an overview of the series and talked about the current state of the music industry with AI creeping into songwriting. In part 2, I shared some history of how the current state came about. In this video, we will start discussing the challenges, threats, and problems associated with AI-written songs. Ready? Let's roll! The ease of use and quality of output of AI songwriting platforms provide many benefits, but they also create a significant number of very serious challenges, threats, and problems for human songwriters and the music industry in general. This video and the next will explore several of the most concerning challenges, threats, and problems, or CTPs as we'll call them, associated with AI-written songs. CTP number 1. AI companies train their platforms on human creators' work without permission. Before an AI platform can generate new output like new text or new music, it must first have a set of like data on which it is trained, called a corpus, the plural of which is corpora. The output is generated one piece at a time, such as one word in a written document or one note in a musical composition, in accordance with a statistical model that computes the probability of the next word or note. The probability is calculated through a training process that allows the AI platform to analyze the entire corpus. How a corpus is compiled can vary from innocuous to borderline villainous. AI platforms are known for populating their corpora through a controversial process called AI scraping, where content, ranging from text, images, music, etc., is captured from where it is hosted online and saved into the AI platform's databases without the knowledge or permission of the owners of that content. Many of the artistic works that are scraped are likely to be legally under the protection of copyright. For the purpose of this video, a distinction will be made between A, corpora that consist only of data, that is text, music, artwork, etc., that have been approved for that use by the copyright holders thereof, and B, corpora that contain data that have been added, including via scraping, without the consent of the copyright holders, which we will call a non-approved corpus in the singular and non-approved corpora in the plural. When content has been added to a non-approved corpus, the next risk is that the new content that is created based on such content in such non-approved corpus is so similar to the pre-existing content that it results in an infringement of the copyright of the original content's creator. CTP number 2. The output of AI songwriting platforms may infringe on copyrights, but the law is far from settled. There are several aspects of copyright law that might be applied to the output of songwriting platforms. United States copyright law is contained in Title 17 of the United States Code. The basic framework for current copyright law is the Copyright Act of 1976. A few of the many important sections of Title 17 that provide and limit protection for copyright holders include Sections 101 and 103, which define and set forth rights and limitations associated with derivative works, and Section 107, which covers fair use. The doctrine of derivative works protects copyright holders against the unauthorized creation of certain new works that are based on the copyright holder's works. The doctrine of fair use allows third parties to use copyrighted works without the permission of the copyright holder in certain situations. Each of these doctrines will be discussed separately in this series, with particular emphasis on the implications involving non-approved corpora and beginning with the doctrine of derivative works. The protection of copyrights against AI infringement on the basis of derivative works has begun to make its way into the courts. A derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work consisting of editorial revisions, annotations, elaborations, or other modifications, which as a whole represent an original work of authorship, is a derivative work according to Title 17 United States Code Section 101. Only the owner of copyright in a work has the right to create or authorize someone else to create a derivative work. Therefore, it would seem that an AI-generated song based upon one or more pre-existing songs would be a derivative work and thus a violation of the original songwriter's copyright. However, the lack of resolved AI-related derivative work court cases in the music industry and the limited number of resolved AI-related derivative work court cases in other industries so far have seemed to suggest that protecting one's copyright from AI derivative works isn't exactly a slam dunk. In the case of Cadre v. Meta Platforms, Inc., the California Northern District Court held that there is a high burden of proof on a plaintiff claiming that an AI platform created a derivative work from the plaintiff's original work, in that case, books. Writing for the court, Judge Vince Chabria said that, quote, to the extent that they are not contending an AI platform spits out actual copies of their protected works, the plaintiff would need to prove that the outputs or portions of the outputs are similar enough to the plaintiff's copyrighted works to be infringing derivative works. And because the plaintiffs would ultimately need to prove this, they must adequately allege it at the pleading stage, end quote. The takeaway here is that an AI platform's use of a copyrighted work for training that was used to create a new work is not enough on its own to construe the new work as a derivative work. The output must be substantially and provably similar to a copyright holder's work. That takeaway is likely to be tested soon and often. Another pending case in the same district, Anderson v. Stability AI Limited, could overturn or further entrench the precedent in Cadre. In Anderson, a group of visual artist plaintiffs filed a class action lawsuit against the creator of the Stable Diffusion AI software product, which enables the output of images based on user prompts. The plaintiffs claim that 5 billion images, including the artistic works of the plaintiffs, were allegedly scraped and used for the purposes of AI training. The claims survive the defendant's motion to dismiss based on 3 facts. 1, Stable Diffusion is built to a significant extent on copyrighted works, and the way that the product operates necessarily invokes copies or protected elements of those works. 2, Stable Diffusion was created to facilitate its users' copyright infringement by design. And 3, many people knowledgeable of the industry agree that training images can sometimes be produced as output from the AI products, according to the court. This case is certainly analogous to the music industry. Existing visual art used to create new visual art is not significantly different than existing music used to create new music. The trial in this case is set to begin on September 8, 2026, and the outcome is likely to have near-term reverberations on AI in the music industry. These cases illustrate the emphasis on the output of an AI platform in addressing the question of whether an AI-generated work is a derivative work and therefore a potential violation of the copyright holder's rights. The doctrine of fair use is different in that, applied to AI, it can analyze not just whether the output of the AI platform is similar to a pre-existing work, but could consider a broader context of the relationship between the AI-generated work and that pre-existing work. Fair use is seemingly the strongest defense of an AI platform against a copyright infringement claim for AI scraping. Fair use is an affirmative defense that, if proven by the defendant, defeats a copyright holder's claim. Fair use permits one to use a copyrighted work without the copyright owner's consent for certain purposes that include, but are not limited to, criticism, comment, news reporting, teaching, scholarship, or research. However, fair use is often determined on a case-by-case basis, considering the following 4 factors from the Copyright Act. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. An oft-cited example of the successful use of fair use as an affirmative defense is the U.S. Supreme Court's holding in Campbell versus Acuff Rose Music, Inc., and in that case, the court held that 2 Live Crew's rap parody of Roy Orbison's song "Oh Pretty Woman" was fair use, mostly on the grounds that the claim failed to satisfy that fourth factor related to the effect of the use upon the potential market for a song that served as the basis for another work. Campbell is cited as precedent in other fair use cases, even where the facts are quite different. An ongoing and growing debate in the creative and legal communities is whether fair use defense for AI scraping could be as successful as the fair use defenses in Campbell and other pre-AI cases. Fair use has been called technology companies' most common argument in defense of its AI model training practices. This is such a hot debate that the United States Copyright Office issued a 108-page report on the subject. The report is authored in such a way to avoid broad brush statements and to defer to a case-by-case application of those foregoing 4 factors. However, the report does nod to the intent of the platform in offering guidance to decisions. Quote, "When a model was deployed for purposes such as analysis or research, the outputs are unlikely to substitute for expressive works used in training. But making commercial use of vast troves of copyrighted works to produce expressive content that competes with them in existing markets goes beyond established fair use boundaries." End quote. This touches on that important fourth factor of fair use, that AI-generated songs will have an effect on the market for the songs on which they were based. And the report goes deeper on this point. Quote, "The speed and scale at which AI systems generate content pose a serious risk of diluting markets for works of the same kind as in their training data. If thousands of AI-generated romance novels are put on the market, fewer of the human-authored romance novels that the AI was trained on are likely to be sold." End quote. This voluminous report gives the public and the courts a lot to consider. However, it must be kept in mind that the Copyright Office's report is not binding law. The report even discourages the development of statutory law, calling government intervention premature at this time. And shockingly, the day after the report was issued, President Donald Trump fired the Register of Copyrights and Director of the U.S. Copyright Office, Shira Perlmutter, according to a statement issued by U.S. Representative Joe Morell. The statement mentioned the issuance of the report and alluded to Perlmutter's apparent refusal to, quote, "rubber stamp Elon Musk's efforts to mine troves of copyright works to train AI models." End quote. As such, escalation of controversies through the judicial branch seems to be the most likely path towards acquiring clarity on how well protected copyright holders' rights are from AI trends. And protecting one's intellectual property rights under a copyright regime may not be the only legal avenue songwriters may be able to pursue. A recent case may shed some light on the level of faith that intellectual property rights holders may have that the courts will protect their interests under a copyright regime. In Reddit Inc. v. PBC, Reddit sued PBC for scraping its content for the purposes of training its AI assistant Clyde. But rather than suing for copyright infringement, Reddit sued for breach of contract, citing a violation of browser app terms of service, and under a number of torts, including unjust enrichment, trespass to chattels, tortious interference with contract, and unfair competition. Though PBC removed the case from state court to federal court where copyright claims are adjudicated, the California Northern District Court granted Reddit's motion to remand the case to the San Francisco Superior Court, where contract and tort claims are adjudicated under state law. This was obviously an interesting development that could affect how scraping claims are pursued in the legal system. But even with multiple potential legal approaches to enforcing intellectual property rights, Human songwriters face uncertainty as to whether their work will be protected in court or even in everyday industry practices. Unfortunately, the courts are not the only battlefield where the human versus AI war is being fought. AI is infiltrating songwriters' direct revenue stream as well. And that is where we will pick up in the next video in this series. So be sure to like this video and subscribe to the Clyde channel so that you don't miss out on our exploration of protecting the art and business of human songwriting from an AI apocalypse. Thank you so much for watching. I'll see you next time.